We thank you so much for watching Law School Made Easy at Law School Made Easy 256. Thank you so much for subscribing, sharing, and liking our videos. Today, we are going to discuss contract law, and particularly want to look at illegality, the illegality of a contract. What do we mean by an illegal contract? What do we mean by illegality? And then we go in contracts which are illegal, and then we have also um, contracts which have been made illegal by the statute, by the law, particularly of Uganda. There are contracts which have been made illegal in the law, and then those other contracts which are contrary to the public policy. So with me is Council Saddam Abala, who has come back again to take us through this concept. Council, thank you so much for coming, for honoring our invitation. The last time you're here, we're doing courts of judicature, and I can tell you it is one of the best trading videos. We thank you so much. That's why we want to call you back and we go through the illegalities. Council, most welcome. You can say hi to the viewers.
Thank you, my brother. Good afternoon, ladies and gentlemen. I want to thank you for sparing your time to follow Law Made Easy 256. It is a pleasure to be with my brother here once again. Of course, the last time we were here, we handled the hierarchy of courts. And now, guess what? We are back again. And we will still be back for more other episodes. So stay tuned. We have a lot to unleash to you. Stay tuned, follow and like the videos, and give us feedback as well.
Yes, thank you so much, Council. The last time you came here, you remember we had a full long video of over 37 minutes, and we didn't have water, but you can see we are improving. Now we have water for our guests and all that. But let's go straight into illegality. A first-year student in second semester, when they come across this concept illegality, of course, they have been hearing it about voidable contracts, and many things. But the issue is when they hear of a contract that is illegality in contract law, what should come to their mind? What do they mean when they say this contract is illegal?
Thank you so much, my brother. I want to, for starters, I want us to take the literal meaning of what something illegal means. What do you get to understand when someone tells you something is illegal? From the literal meaning of it, from the common man's understanding. Something illegal, that means something that is prohibited. And in this case, we are looking at it in the legal perspective.
Not accepted.
Not accepted. But the best way to put it is that it is something that you cannot enforce in any structure of courts in Uganda. Meaning, when someone is talking about the principle of illegality in contracts law, that simply means that these are kinds of contracts that you, the parties, cannot enforce.
It's a contract, but you cannot enforce it.
You can't enforce that contract in any courts of judicature or in any part of Uganda, within the jurisdiction of Uganda. You can't enforce it. Meaning, what do I mean by enforcement? Let me just break that a little bit down. By enforcement, I'm trying to mean that, you see, both parties to a contract have obligations.
Yes.
Okay?
Yes.
Party A and Party B. Both of them
have obligations.
Look at the standard contract, both of them have obligations. And therein embed the aspect of enforcing those obligations. That means if my obligation is to pay money to Walter for supply of given materials, and whatever he's supplying to me is illegal, is prohibited, that means if I fail to pay, Walter cannot take me anywhere to enforce the contractual obligation that I am supposed to partake.
Counsel, let me give you a scenario. Maybe you tell us if it falls into contracts which cannot be enforced. If I hire our cameraman here, Alvin, I tell him go and kill for me woman X. So I give him, I tell him I'll pay him 10 million if he kills woman X. I pay him 5 million. He successfully kills the other person. Then he comes back to demand for the balance, which is 5 million. I tell him I'm not paying him.
Very good. That example fits in perfectly to try and bring the idea of legality, contracts that cannot be enforced. Now, you pay 5 million.
Yes.
I am demanding 5 million.
Yes.
I have fulfilled my obligation of killing the woman.
Yes.
So now, what is outstanding is 5 million.
Yes.
And you refuse to deliberately pay.
Yes.
I can't. There is no avenue where I will take you and sue you, and I have the contracts enforced.
But counsel, we are saying he worked. He has killed someone.
He worked. Now, the best way to describe it is that contract is void ab initio. That means it does not exist from the word go. Irrespective of the fact that you paid 5 million before, does not make it right. You get the point?
I get it.
So it is void
ab initio. From the start, it was the wrong one.
It ceases to exist in the eyes of the law. There is no way you're going to enforce such a contract. That's what it means. You see, the framers of our statutes were very deliberate. I'm well aware you and our colleagues understand the concept of freedom to contract.
Yes.
That you have the liberty to contract with any other party.
Anyone, yes.
On various terms. But now, you will be gauged. The cage is that when you go extra and enter into things which are not permitted by the law, as we will see as we proceed, you have no avenue to enforce such a contract. Be it using the criminal avenue, be it using the civil way, or be it using the humanly way, because ideally, law is all about common sense and the conscience of the person.
Yes.
So, in short, we are saying illegal contracts, or the principle of illegality as regards contracts law, simply means these are agreements entered into by parties which are not enforceable
by law.
That is, in short, what
legality means. Thank you so much.
Yes.
Now we can move to, now that we understand the meaning of illegality, we can now move to forms of those contracts which are being refused by law to be put into.
Now, before we move to the forms, I would like to make reference to the Contracts Act.
Yes.
You know, before the laws were revised, it was Section 19 of the Contracts Act, but now it is Section 18 of the Contracts Act. Of course, now it is CAP 284.
Yes.
You remember, it was just Contracts Act of 2010.
Oh, yes.
But now we have it as Contracts Act of
Contracts
Act CAP 284. So Section 18 is the baseline.
Yes.
Is actually the statutory provision for
illegality
for illegal contracts. Briefly, just if you look at subsection 1, it says a consideration for an object of an agreement is lawful. That is the general rule, using as general rule, except where the consideration of object, paragraph A, is forbidden by law.
It's not accepted by law.
Accepted. However much the consideration may be, it will not be enforced and it is illegal. So, for any student of contracts law 2, of semester 2, this has to be at your fingertips. That whenever you hear of illegality, you need to quickly refer back to Section 18 of the Contracts Act and the other subsequent provisions still provide for illegality under the Contracts Act. So, going into the different types of contracts of illegality, the types. Number one is we have contracts prohibited by the law. We earlier alluded to the fact that if the example like he gave, if we entered into, I want to give you another example. If I hired machineries to go and smuggle Okay? Smuggle my goods across the border, be it from Kenya, be it from Congo into Uganda. Okay? Such a contract would directly fall into under contracts prohibited by the law. That means the activities under which the parties are engaging,
the law has already prohibited them. They are not accepted.
They are not accepted under the law. Example number 2, under the Land Act. You see, a foreigner is not allowed to own land under the freehold or the milo tenure. Foreigners are only allowed to hold land under a lease and not exceeding 99 years. So, in a given transaction, if a foreigner enters into a sales agreement or an agreement to purchase land, that essentially amounts to a contract.
Yes.
And he buys or he acquires a freehold or a mile land, such a contract is illegal. It is prohibited.
Because the law has prohibited foreigners from owning land.
Exactly.
Very good.
So that is prohibited under the law, specifically under section 40, subsection 4 of the Land Act. So such a contract would directly fall under contracts prohibited by the law. Let me just oppose that with the case law. We have the case of Misri Amar Singh versus Swerawani Nofunira Kulubia. So the full citation is, this is East African Law Report. Yeah, it is East African Law Report 1963 at page 408.
So what happened in this Kulubia's case?
Now, Kulubia's case, the brief facts of this case is that a non-African, by that I mean a foreigner, had acquired land under the Milo tenure. Okay? And you see, by the provisions of the Possession of Land Act, specifically section 2, required that the Luchiko would approve and the governor would approve such transactions. So this did not happen in this case. And of course now, when they tried to transfer, the respondent, when he purported to get possession of the land, the plaintiff, with the knowledge, having known that this transaction would ideally be an illegal transaction, refused to hand over possession. So when he went to the court of first instance, the trial judge, of course, in his reasoning, he said there was an equal fault on both parties. What we call the pari delicto. That means each party had faults on their side. The plaintiff had knowledge that indeed a foreigner will not acquire land under the Milo. Now, the foreigner and the respondent did not also address himself to understand whether he was eligible
to own land
under Milo or not. And as you well know, ignorance of the law is no
defense.
So on appeal, of course, the Privy Council held that the respondent had no right without the consent of the Lichiko to acquire land under that tenure. So that therefore means that transaction was null and void. So the plaintiff remained with the owner and the respondent lost money. So ideally, that's what we're trying to say, that contracts prohibited by law, there's no way you can go and try and enforce such contracts because they're illegal, they are not allowed.
The law has prohibited that.
It explicitly. Secondly, you look at contracts contrary to public policy. And if you look at what public policy means, public policy still relates to the aspect of the government, the law.
Absolutely.
In that it is these are regulations, or actually a policy. It's something that the government intends to undertake or not to undertake. Like, for example, we now have what we call the PDN. It's a policy of the sitting government. It's a policy that has been passed, meant to help in terms of poverty eradication. So you have contracts certain contracts that fall contrary to any policy passed by government. By public, it means that it is the government mandated, the government in charge of such policies. So contracts that tend to contravene such policies, like for example, if I entered into a contract with the parish chief, okay, not to distribute the PDM money. Of course, that is a simple example I could use. Not to distribute the PDM money. That is already something contrary to the government, the public policy. And that will directly fall under this category of contracts. That even if the parish chief fails to enforce his obligation under the contract, there's no way I can take him and enforce that contract. And there's no way he will take me and ask for enforcement of my obligations under that contract, because it is outrightly against public policy. So that is the second type of public policy. Quickly, I will also maybe discuss case law of Christ for All Nations versus Apple Insurance Co-Limited. The full citation is, it is a case of 2002, volume 2 at East African Law Report at page 366.
Yes.
So the brief facts of this case, of course, relates to an insurance policy. The insurance policy holder, in terms of the plaintiff, had undertaken a policy, an insurance policy, which was previously prohibited by the government of Kenya, because this is a Kenyan case. So when it came up for redress, legal redress, it was held. Court stated that public policy covers, because now court was trying to give the coverage of what public policy means or entails. Court said public policy covers anything that is inconsistent with, one, the constitution,
yes,
two, any written law of Kenya, or against the national interest of Kenya. Just another quick example to substantiate that. You see, we have the national security interest of Uganda. If anybody entered into a contract with any militia group or any terrorist group to sabotage the national security of Uganda, such contract would fall squarely under this category of contracts against public policy, because you would be now, the public policy of the government of Uganda or any other country would be, in terms of security, would be to protect and ensure security prevails.
Actually, according to the penal code, anybody who comes with the malicious to interfere, that one is terrorist, and the punishment is death.
Exactly, exactly. So such would fall under the contracts against public policy. So the third type of contracts which are illegal under the Contracts Act are contract to commit a crime or a tort or a civil wrong. Okay? We earlier on mentioned similar things, but the two are different. Now, this is obvious from the wording of it, that in case me and you enter into a contract to maybe say cause harm to the students of IUIU, okay? Now, such contract would also directly fall under this type of contract.
That's a contract to commit a wrong, a crime, or a civil wrong.
Or a civil wrong, or a tort, falls directly under illegal contracts. In that we all understand what the term crime means, something prohibited by the law. You see, you can't hire me to go and rob the bank and you expect such a contract to be enforced. That would tantamount to the aspect of contracting one to commit a crime.
The rule is you cannot benefit from a crime.
Exactly. That is the best word to actually term. You can't benefit from a crime because it is something prohibited by the law. I also want to quickly share with our viewers case law of Braceford versus Royal Insurance Company Limited. The full citation is, it is the case of 1937 at volume 2 KB at page 197.
So in Bestford, what's the insurance? What happened in there?
Now, this case involved relatives, that the relatives of a deceased person had committed suicide. And while they committed suicide, the idea was to try and to claim from the insurance company an insurance claim of about £50,000. And you see, that was already against the crime, because you can't kill yourself. Like he said, you can't benefit from a crime.
Because he wanted to, he killed himself so that his relatives could benefit from the insurance.
Exactly.
So court held that?
Court held in this case that such contracts under such a policy would be null and void. That means it would be illegal, it would be unenforceable. That no insurance company would pay such a claim, because first of all, it is outrightly wrong that he did an act and he wanted to benefit by extension through the relatives from such an act. So such was held to be illegal and not enforceable.
So the rule is you cannot benefit from a crime. You can't commit a crime with the intentions of benefiting
from it. That is totally unacceptable. The fourth, I think, yes.
Yeah, the fourth.
The fourth type of illegal contracts. These are the contracts prejudicial to the administration of justice. What does this mean? That if the best term would be you want to take away the powers of courts in administration of justice. That you enter into a contract and you have provisions that will ensure such a contract will not be subject of legal redress. That means we enter into a contract with him, and one of the provisions that we have under such contract is that you cannot seek legal redress. There are such contracts there are such provisions which exist within contracts, that you're limiting somebody
from accessing
justice in terms of legal redress, in terms of a remedy, even to an extent that you don't need an arbiter, like someone who would come to arbitrate. You don't even have such kind of. So when you have contract that embed such provisions which prejudice someone's ability to seek legal redress, such contracts are illegal.
I think they include the chin party.
Yes, the category one is maintenance and chin party. That is one of it.
Yes.
Now, a contract of maintenance arises where a person encourages and supports a cause of litigation in which he or she has no interest. For example,
that is maintenance.
Yes. For example, my brother here would have gotten a misunderstanding with another party with whom they had a contract, maybe say for supply. Okay. Now, for you, because indeed you saw that at times you see there's no light at the end of the tunnel, and you have no interest ideally in that case. Okay. But you're trying to push to have a cause of action instituted in courts of law, but ideally you have no interest in that case.
You're just doing it because maybe you hate the other person.
You hate that person, you want to sabotage. You want to portray an image outside there.
So that court is called contract of maintenance, where you support litigation against anyone, but you have no interest.
No interest in it. You just do it for the sake of it, but you have ideally no interest in such a case.
Agreed.
The most common example would be, maybe if I can bring it down. At times people tell you, I hate so and so. But if you ask him, why do you hate him? No reason.
No reason.
Now, this will directly fall under this such of category. That you want to pursue a cause of action, but ideally you have no interest in that. But because you just have maybe a vendetta against the other person, maybe you want to send out a message.
You are biased.
You're biased. You see, you just want to confuse things here. That will fall directly under contract of maintenance. Now, champate is a contract where a person is given assistance in bringing a cause of action, either financially or by provision of evidence in return for share in the rewards arising from the action, if successful.
Oh, so chimpati, you give support to any cause of action, litigation, but with the interest of getting on a share if it succeeds.
If it succeeds. For example, you know, there are some mafias, I want to use that word, there are some mafias who understand the government cartel. Okay? Now, you very well know that governments only, at times, they take long in terms of paying money, be it compensation, be it money for supply.
Yes.
Now, I may be knowing that Party A has given amount of money it is demanding from the government. And because normally government delays in such payments, now I would want to entice such a person so that he or she institutes a suit that will be financed by myself, or I will have evidence adduced to support his or her case. At the end of it all, so that I will benefit from the benefits that will accrue from such a case.
That is if the case succeeds.
That will squarely fall under the case of Champati.
So, Counsel, am I right to say that in terms of the Champati arguments, these things lawyers do that, or even not even lawyers, other people, they say, let me finance you in this cause of action, or maybe against land, over land, but after you give me 10 acres. Does it fall there?
Now,
when we succeed, you give me 2 acres of that land. I take this.
That will squarely fall under this type of contract. Chimpati contract. That you because you have an interest, in a given subject matter, you would provide finance, or even like the example you have given, provide the legal representation to the party, which could be through another law firm, that if it succeeds, you would benefit by having so much acres
of land.
Very good. That will fall directly under the contract of Chimpati. Now, to support this, we have Ugandan case laws.
Yes.
The locus classics, the case of Shell Uganda Limited and others versus Rock Petroleum and others. And then we have the case of Kawamara Sam versus Richard Juko.
Kawamara, yes.
Now, in the case of Juko, that the defendant, who is Juko, engaged the plaintiff as his agent in trying to pursue his claim from the government of Uganda, which amounted to about 216 million. Okay, which was awarded, as a compensation by the High Court of Uganda.
And Kawamara went through.
Now, they had agreed that the commission would be 45 million shillings.
Yes.
Now, when the plaintiff tried to enforce that contract to ensure that he or she gets the commission that was agreed, court held that this was a Champati type of contract,
which is illegal. So there is no claim.
You can't enforce it. You can't claim it, and you have no avenue to enforce such a contract.
An agreement, the contract, yes,
because it is
illegal,
prejudicial against the administration of
justice.
So
meaning that it is a right of everybody to get justice. Absolutely. The moment you put something that either it's going to delay or you want to benefit from that, from somebody getting justice, it becomes illegal. Very good.
Okay. We all know, we're all aware that Article 28 of our Constitution, fair hearing, the principle of legality, where all now this aspect would fall. So, going to the other type of contracts which are illegal, now, contracts tending to corrupt public life.
What do they mean? contracts tending to corrupt public life?
Now, this would ideally mean that you enter into contracts with public officers, with people who work under the public sector. By that we mean the government ministries, the different departments of the government. That will be the public sector. Now, you enter into contracts with them to be able to corrupt them and acquire given services as a result. For example, we have in Uganda, we have the procurement, the procurement and disposal, or every other ministry or department has the procurement department, which actually has, which is the most finance departments within all ministries, because they normally have
they want to buy things,
so they are in millions of shillings.
Absolutely.
Now, you enter into contracts to compromise or to corrupt such public officers to be able to either one, award you those contracts, the tender, two, that to try and divert from the agreed policy statements in terms of work implementation of those very departments. So such kind of contracts would squarely and directly fall under contracts that tend to corrupt public life.
So, Council, those days, people who stood for mayor in Kampala here, I remember many years ago, if you stand for a mayor, but the moment you declare that I'm coming to be the member, you would get rich people in Kampala who would ask you and tell you, we are going to give you money, support you, and you win. But when you win, I want the tender to take over all the markets. I want the tender to be the one in charge of all public toilets in Kampala. I want the tender of different to be people who will be sweeping Kampala. The cleaners, you give me that tender. So they support you to win the election. So when you win the election, when you get there, you are supposed now to fulfill. Now, my question is, from what we are discussing, corrupting public life, does that fit in?
That would fit in perfectly.
Yes.
Because one, you see, a politician ideally is the head, is the political head of an institution, say like Kampala. And by extension, he or she amasses a lot of power to influence different decisions at different levels.
Yes.
So that would ideally fall under contracts to corrupt public life, because the parties that pay such monies, they already have a target. That you'll give all tenders or markets to me. You're already corrupting public life. That means that already undermines merit-based award of tenders.
So, Council, in the event that I become the mayor of Kampala and I refuse to give you the tender, but you gave me money, I came to office. So, if you go to court, courts will rule in my favor?
They're not ruling in your favor. They're not ruling in your favor. Such a contract is illegal.
It cannot be enforced.
It can't be enforced.
But
rather, court may constitute itself as a court of equity, because money has exchanged hand, and then maybe ask the money to be refunded back.
Very good.
You're also aware, I know, that there is a remedy of tracing, that money can be traced. But courts, we have jurisprudence that shows, we have case law that shows courts have always taken a stand that such contracts are illegal and they are unenforceable. You can't enforce such a contract. Like we said, it will be void ab initio. From the word go,
it was the wrong contract.
It was the wrong contract. From
you were corrupting public life.
Correct. There's an English case law of Parkinson versus College of Ambulance. The citation is the case of 1925, volume 2, KB, at page 1. Now, the brief fact of this case is that the secretary of the Charitable Organization Society promised the plaintiff, who is Parkinson, that he would procure him a knighthood of about £3,000. Now, when the plaintiff paid,
that is Parkinson.
When he paid that money, he didn't receive the title. Knighthood in the UK is a very respected title awarded, like how one can be called a sir. So knighthood is a very prestigious title in the UK. So now the secretary tried to persuade the plaintiff that you pay $3,000 in exchange. I will find a way of awarding you the title of knighthood. So when he paid,
he was not awarded.
He was not awarded the name. So when he sued to recover the money, court held that the substance of that agreement was illegal. You get the point?
Yes.
That it was illegal, that he could not enforce such. So both parties will remain with their rights. You have lost money. On the other end, this one has received the money, but there's nothing you can do to him or her.
That is Parkinson versus Royal Ambulance.
Royal College of
Ambulance.
Now, another category of contract that fall under the legal contract is contracts to defraud revenue. Now, this also
before you go to the contracts to defraud revenue, we want to thank you so much for watching Law School Made Easy at Law School Made Easy 256. Kindly subscribe, share, like our videos. So far we are discussing the forms of illegality, the contracts which are illegal. We have so far discussed the contracts contrary to the statutes, the law, prohibited by law, contracts contrary to public policy. We have discussed contracts to commit a wrong, a crime, a tort. We have discussed contracts to judicial, to administration of justice. We have talked about maintenance, sympathy agreement, and very many others. We have also discussed contracts to corrupt public life, and right now we are discussing the contracts to defraud revenue.
Now, contracts to defraud revenue simply means that you enter into a contract with people or with bodies such as URI, or by extension its officers that help run the day-to-day activities of such bodies, to be able to defraud such a body. But of course, by extension, you're defrauding the country of revenue. For example, I have a mansion in town. I have several businesses in town. You're well aware those businesses attract either income tax or property tax or rental income tax, or even in some cases VAT if it is a commercial premises. Now, I may enter into an agreement with one of the commissioners who is directly in charge of handling such matters. And the substance or the subject of the contract may be, please exonerate me, or not to allow me to pay the taxes which are due. That would fall under the contract to defraud revenue, which would be illegal, which would be unenforceable. That I, as a party who was trying to persuade the other one to ensure I have a favor, would not enforce. At the same time, the second party to whom the promise was made cannot enforce such a contract, because it is meant to defraud the respective body of revenue, of their revenue, which by extension means you're defrauding the country.
Also, I have two examples, two examples to ask about. One, we have cases in Kampala here. There are those mandatory pay monies, taxes we are supposed to pay when we have a shop in Kampala, ABCD. So when you don't pay that monthly license, they will come and put a seal on your door. Now, but when we see them, when they have come to seal off our shops, we talk to them, say, Mandeka, give him like a 20K. I give him personal 20K to allow me continue without paying the tax. Or we even call those people, tell them, you find a way to make sure that I don't pay this month. I'll give you your 15K. Does that mean I'm defrauding revenue?
Yes, that would squarely fall under the contract to defraud revenue. Because there is an ostensible authority that the people who come to close your shops possess.
Absolutely.
That they are a representative of a bigger body, for example, KCCA, that ideally the rationale of closing is to ensure that you comply, you pay.
Absolutely.
But now when you come and try and pass money, 50, 100 to him, and he allows you continue, that means, number one, you're sabotaging the revenue that would have been collected by KCCA.
Absolutely.
To help in the planning purposes of the city. You already defraud KCCA of that amount of money.
And even then, that money is taken to the consolidated fund.
Exactly.
So you are defrauding basically the country. Then we have another policy. This one, when we used to bring rice, people would bring rice from Kenya. Now what you do, you tell the bus guys, put this under, you hide this, that when you reach the border, you just pass minus paying the taxes, or they are not seen. If I think even the Bitenji, the time when Bitenji used to come from Kenya, and then we do that, make sure that you either pack it, put somewhere, but you pass the border minus it being checked. Are we defrauding revenue?
You're defrauding revenue. That will also fall under the contract that defraud revenue, which are illegal. It can't be enforced. In any case, when I fail to pay, you can't take me anywhere. You can't enforce it because it is illegal. Yes. So we have the other contracts that fall under the illegal contracts. We have contracts that are sexually immoral.
Sexually immoral.
You see, when you enter into a contract with a prostitute, like for example,
with the prostitute,
like for example, at times people who run hospitality business, they tend to bring those sex workers around their premises that will help entice more customers come to their premises.
Yes.
So if one has such a contract that I, a proprietor of a given hotel in town, contracts a number of sex workers to come and be as the quick spot of attraction for my customers, to help give them the services, that will tantamount to contracts which are sexually immoral.
Because already prostitution by the laws of Uganda is not allowed. So the moment you harbor prostitutes, you get them to your premises, that is already a contract which is sexually immoral.
In that such a contract, I, as the proprietor or as the one contracted, cannot enforce it. Neither can the sex worker enforce it. Such a contract.
Because already from the start, from the word go, it was a wrong contract.
It is wrong. Okay? So
very good.
The sex worker cannot sue me to recover the monies, and at the same time, I cannot have a cause of action if the sex worker fails to show up at my premises.
Oh, yeah.
Okay? That will squarely fall under contracts which are sexually immoral. And they are illegal contracts. Okay? We also have, maybe this is the most contentious one, contracts in restraint of trade. Now, what does this mean? That from the write-up of Farmstone, it defines contract in restraint of trade as one by which a party restricts his future liberty to carry on trade, business, or profession in such a manner and with such persons as he chooses. Let me break it down. I contract you, for example, as a host for my show on a television. And then within that very contract, I have provisions that restricts you from hosting similar shows at a future date.
That if I leave your television, if maybe you sack me or I go on my own, the contract is that I'm prohibited from working on the same show, doing the same thing at another television for a given period of time.
Isn't
that unfair?
Now, of course, legally, the general rule is prima facie, from the face of it, contracts in restaurant of trade are void. They are illegal. From the face of it, they're illegal. But however, it becomes enforceable if it is provided, if it is proved that the restraint is reasonable in the circumstances. That, for example, I have invested so much in you as a host. I have trained you. I have taken you abroad to get further studies. I have catered for so much to make you who you are as a host. Now, it will not be fair for you to just leave and then go and do a similar thing, given all the amounts of money
we have invested in
you. That's why legally, that's why jurisprudence is telling us that so long as it is reasonable in the circumstances, you get it?
Yeah, I get it. Maybe, let's take an example. If we are in Chiburi, for example, and you open up the same business, this is now Chiburi, you open up the same business at Kabaragara, very close to here, that was not accepted. But if you, in my opinion, but if I go same business, I open up something in Karamoja. If I go to Karamoja, my opinion is that there I can work, I can operate. It might be reasonable because the distance is very far. But if I'm within the same jurisdiction, does it apply?
That's why we're saying, so long as it is reasonable. Now, the example that you gave would be a perfect exception for that. That you go far distances away.
I go to Karamoja.
You go to Karamoja. In any case, you will not be my rival.
Absolutely.
In any case, you will not be a competitor to my business. And that will not in any way sabotage the existence of my business.
Your business, yes.
That will perfectly fit in the exception of it. But I am in Chibuli.
You go to Kabalagala.
You go to, not even Kabalagala, you're within Chibuli.
You're within Chibuli. You are at the depot that goes to
Mutajaz. And open up a similar business. Now,
the restaurant will work.
Now the restaurant will work. This will now come to play. Okay?
Yes.
Because if you look at Article 40, Clause 2 of our Constitution, 1995 Constitution, says every other person has the right to practice his trade, his profession, and everything. Now, that's why we say this is where now the contracts in restaurant of trade becomes, like we say, prima facie void, as per that provision of the law, the Constitution. But however, exceptionally, as you know, every general has an exception. Exceptionally, depending on the circumstances, which are reasonable, I can be able to restrain you from doing a similar business. But if you go to Arua, you go to Congo, you go to Sudan,
you can continue.
I have no business.
I cannot restrain you from there.
I can't.
Okay.
I can't. So that would actually of recent, I think 3 to 4 months ago, there's a similar scenario of a radio host. I think it is either she's called MC Evelyn or something. Evelyn something.
At Galaxy
FM, that kind.
Yes.
So that was a typical example of the contract investment
of trade.
That there was a provision within her contract that restricted her from engaging or getting employed by a rival TV station
or radio.
So that will be a perfect example
for this in trade
to fit in the example of contract investment of trade. Now, then lastly,
yes,
we have gaming or wagering contracts.
Gaming
or wagering contracts. And if you look at the Contracts Act, specifically the Contracts Act, specifically section 64.
Now 63.
63 now. 63. It was 64 now 63.
Now 63.
62, I think. Okay. Now, what does this
Gaming.
What does it refer to? The act itself defines a wager as a promise to pay money or other consideration on the occurrence of uncertain events. Gaming or wagering is illegal in Uganda except if carried out without a license. That the act is trying to tell us that you pay or you agree to offer consideration when an event which is uncertain occurs. So such would fall under the aspect of a gaming or a wagering contract. Like the, what do you call them? The Fort Bet,
the betting companies.
The betting companies.
Bet Power, Sports Betting,
and
SBA.
That me, party A, walks in to pay some given amount of money.
Waiting for a game at a later date.
Waiting for a game to happen and specifically a given result to occur. Now, such would amount to
an illegal contract.
Unless carried under the license. Now in Uganda now we have the Gaming and Lottery Regulatory Board that licenses, regulates all those betting companies, and all others. There are even others that I don't know, that mandates them to carry such kind of activities in Uganda.
In Rwanda, the gaming companies will refuse. The president said that if somebody bets on 11 games and is supposed to get 10 million, he puts his 20,000 or 10,000, and then only one team loses, meaning that he has failed to win the 10. So for him, he says, you pay him the 9 teams he has won, and deduct the other one. So the guys just when the one came to Uganda.
and actually going by what is happening, like the example you've given, in Uganda, you find some people pay, he's sure he's going to win 100 million. And he bets about 9 matches or 5. So long as one of the teams loses out,
you don't bet anything.
It cancels his money. Now you see, you are benefiting from people's sweat.
Absolutely.
Which becomes, that's why the framers were very deliberate that such would be for occurrence of uncertain events that would amount to an example of illegal contracts.
Only if they have a license, then the operations can be.
Exactly. So that marks the end of the different
categories of contracts which are illegal. Thank you so much. Any effects?
Well, if you look at the Act still, we look at Section 18, previously 19.
Yes.
That it stipulates that such contracts, for example, that an agreement made without consideration, that consideration or an object of an agreement is lawful, except 1, prohibited, that one we looked at it. Paragraph B is of such nature that if permitted would defeat the provisions, that one is captured. Number 3, that involves the aspect of fraud. D, that implies injury or to a person or property of another, is declared immoral. And specifically now if you look at 2, that subsection 2 is to the effect. Now we're looking at the effects. That at common law, the general rule is the legality renders the contracts void ab initio. From the word
the contract is void. The first effect, it renders the contract void. From the start, it is a wrong contract. Non-existent, it was a wrong contract.
From the word go, void. You can't enforce it.
Absolutely.
Like we said, there could be pari delicto on both
The
parties,
parties were
but
all
that is immaterial. That one cannot be enforced. That is number one.
yes.
Now you look at the second effect. That secondly, that the illegal consideration of object had not been effected at the time the plaintiff became aware of the illegality. This therefore means, what does this mean? That whatever benefit was supposed to accrue to the plaintiff cannot now accrue. Therefore, the plaintiff cannot gain anything from such a contract.
Because the contract was anyway illegal.
Illegal. You can't benefit from it because ideally there's nothing to benefit from it. Whatever was expected to be earned, like in terms of, let's say the betting, you put money and you expect more than what you put. You can't gain it because the activity you're engaging in is not warranted under the law. So that will still not have a net effect on what you're supposed to achieve. So basically, I think those are the effects.
Yeah, we thank you so much, Council Saddam. Thank you so much for your time. Thank you for the elaborate discussion. Thank you for accepting to share your knowledge with us at Law School Made Easy. We are looking forward to always inviting you, and we have these discussions. But we thank you so much. Thank you for coming, and please keep coming whenever we call on you. That has been contract law, and we have discussed illegality. With all the cases, kindly watch, subscribe, share, like our videos. Alvin, thank you so much. Stay blessed.